Everybody, clear the court.
Lindsay broke down 3 separate times on Wednesday, including when a forensic pathologist discussed Kora and Dawson's autopsy findings.
And did you perform an autopsy on Kora Clancy on January 25th, 2023?
Yes.
And did you follow that same process with Kora Clancy?
Yes. And then I noted evidence of trauma of the neck with associated injuries of her head and minor injuries of her right arm and of her legs as well.
And in terms of the injuries that you observed, evidence of trauma to her neck, were there also injuries to her face and neck area that seemed to go along with the trauma to her neck?
Yes, there were findings of the head that were associated with the trauma of the neck.
And what were those?
So on her neck, she had a ligature furrow.
As the testimony continues, you can literally hear Lindsay breaking down.
So again, the furrow a ligature is when you have external compression by an object on the neck, and a furrow is simply a pattern of injury that occurs beneath it. It can be an imprint, it could be a pattern, or it could be more developed types of injuries such as bruising or abrasions.
And what about injuries?
You can actually hear Lindsay crying, saying, "I can't do it."
What about injuries?
The judge even notices this and calls for a break.
All right, counsel, let me take a break this time, all right?
All right.
The sound in that courtroom is not something you will ever forget once you have heard it. You can hear Lindsay Clancy before you can see her. She is crying. Not quietly. Not politely. The kind of crying that comes from somewhere so deep it sounds like it is tearing something loose inside her. And then she says 4 words that stop the entire room cold. I can't do it. I have covered a lot of trials. I have sat through a lot of testimony. But I have never heard a defendant break like that, while a forensic pathologist described the ligature furrow on her 5-year-old daughter's neck. And that is the moment we need to talk about, because everything about it cuts directly against the story the Commonwealth is trying to tell. Here is the part I have been turning over in my head all week. The prosecution brought in medical experts to describe the autopsy findings for Kora Clancy. They did it methodically. They did it graphically. And the defense objected more than once, saying this was repetitive, that the Commonwealth was piling on the same descriptions again and again, not to establish facts, but to pull an emotional reaction out of the jury. Judge Sullivan actually sustained one of those objections and told the prosecution to move on. But by then, the damage was done. Not just to the jury. To Lindsay Clancy herself. She broke down 3 separate times on Wednesday. 3. Once when Dr. Stonebridge was testifying about the injuries. Once when Dr. Olson resumed after a recess. And once somewhere in between when the judge called for a short break and everyone in that courtroom had to sit with what they had just heard. My photographer was in the room. He told me at least 3 jurors were crying. The judge had to call a recess because Lindsay's head was on the desk and she would not stop sobbing.
When court reconvenes, Lindsay's head is on her desk and she continues to cry during the testimony.
So your testimony is that you can strangle someone for 30 seconds, let go, and then they die.
I said that in this presence of complete oxygen deprivation, there is a general time frame. And so 30 seconds, I cannot give a specific number to that. Once strangulation occurs, again, the brain starts to be subjected to a lack of oxygen. So whether the ligature is present or whether the ligature is not present, the oxygen deprivation and irreversible brain damage is already occurring.
And there's no coming back from that?
Not without intervention. It's very unlikely. Again, the brain cannot heal those cells.
Did you form an opinion to a reasonable degree of professional certainty, to medical certainty, as to the cause of death of Kora?
Yes.
And what was that?
Asphyxia.
And was that by manual strangulation?
By strangulation.
Now, I want to be very clear about something. Lindsay Clancy has admitted she killed her children. That is not in dispute. She strangled Kora, Dawson, and Callan with exercise bands on January 24, 2023, in the family's Duxbury, Massachusetts home, before attempting to take her own life. She is paralyzed from the waist down. She survived. They did not. And if you are sitting there, thinking that no amount of tears in a courtroom can undo that, you are right. They cannot. But the question before this jury is not whether she did it. The question is whether she was criminally responsible, or whether she was in a state of postpartum psychosis so severe that she could not understand the nature of her actions. And that is where the testimony this week gets very difficult to dismiss. Let me back up for a second and put this in order, because the timeline matters. Lindsay Clancy had 14 appointments with her psychiatrist, Dr. Jennifer Tufts, between September 2022 and January 2023. 14 appointments. Every single one of them was telehealth. Not one was in person.
To the fact that the very first time that Lindsay's psychiatrist, who prescribed her all of these medications, saw her in person was on Friday in court. That is right. All of their appointments, 14 appointments, were done in telehealth.
Elena is right. That's something everyone is talking about. The fact that Dr. Jennifer Tufts, Lindsay Clancy's former psychiatrist, never once saw her in real life until the trial began.
14 appointments?
Yes.
Every single one of them were by telemedicine, weren't they?
Yes.
Until you came in this courtroom Friday, you never saw this woman in person, did you?
Correct.
And did you give her a hug? Oh no, you're on telemedicine, so you couldn't give her a hug, could you?
On top of that, Dr. Tufts was a relatively new doctor at the time she first saw Lindsay, having only officially practiced in that space for about a month before Lindsay became her patient. She's also
Dr. Tufts testified that the first time she ever saw Lindsay Clancy in real life was Friday, in court, from the witness stand.
Yes.
Until you came in this courtroom Friday, you never saw this woman in person, did you?
Correct.
Were you ever concerned about her mental health as a person?
Absolutely.
She was crying. She told you symptoms that she couldn't get out of bed. Isn't that right?
At one time she said it was difficult to get out of bed.
Oh, difficult to get out. Why was it difficult for Lindsay Clancy to get out of bed?
Because she was very depressed.
And did you give her a hug? Oh no, you're on telemedicine, so you couldn't give her a hug, could you? You didn't have any chance to even look at her in person, did you?
I could look at her. It was always a video appointment. I couldn't give her a hug, but that's not actually something.
She never held her hand, never looked at her face in the same room. She prescribed her Zoloft, a medication with a black box warning from the FDA about suicidal ideation, and, in younger adults, homicidal ideation. She never once recommended an in-person visit.
Suicidal ideation and homicidal ideation. There's a black box warning on Zoloft, along with other SSRIs, right?
Under
Yes
age
or no?
for children and adults younger than Lindsay.
Doctor, I apologize. Can you just listen to my question and answer it yes or no? Is there a black box warning on Zoloft?
Yes.
Okay. And a black box warning is required or prescribed by what, the FDA?
Probably.
Probably. And it basically warns that, especially with young people or young adults, that it may cause suicidal or, God forbid, homicidal ideation. Yes?
Even on December 1st, when Lindsay told her she felt hopeless, that she had been close to suicidal ideation the day before, that she could not sleep and was panicking. Dr. Tufts said telehealth did not seem like an issue.
Now, on the interval history, on that date, you indicated that she can't sleep, she's panicking, she had worse depression, intrusive thoughts, she was numb, nothing mattered, I feel like I'm going to die. denies suicidal ideation, but, quote, yesterday, close to it, feeling hopeless. Did you give her therapy and validations after she told you that?
I believe that I did.
What did you do? You got a woman that's telling you that she's hopeless. She doesn't care if she dies. Can't sleep. What did you do to validate on your therapy?
Well, I told her that this was something that we could address, that there was hope, that there were treatments, and there are different types of treatment programs that are more supportive, like partial hospitalization programs. So she knew that she still had options and a reason to hope.
Did you ever suggest to her that maybe you ought to come in to see me rather than talk on the computer?
Talking with her over the video did not seem like an issue. It didn't seem like there was anything that I was missing or that there was any need to see her in person.
The defense attorney, Kevin Reddington, asked her the question that I think every single person in that courtroom was already thinking. You're a doctor. Why are you limited? And Dr. Tufts said it was because of the technology. The technology. She was treating a woman who was falling apart on a screen, and she was worried about drop-down menus and checkboxes.
It was congruent.
You're like a robot. You can't take a pen and write something down. You have to do the drop box and the X's on the computer.
Well, if it's on the computer, I'm limited by the options that are up there.
You're a doctor. Why are you limited?
Because of the technology.
What technology? The fact that there's a form on a computer? You're trying to treat a human being who comes to you for help.
And that's what's most important. What's most important was the treatment, not what is checked off on a box.
Here is the part I did not expect. The defense pushed on her notes. She had written, not hyper, pressured speech. But there was no comma, no period. No clear way to know whether she meant not hyper and not pressured speech or hyper and pressured speech. Reddington read it back to her. She said, I don't care what it says. I know what I meant. That is a quote. That is a board-certified psychiatrist on the stand in a first-degree murder trial saying she does not care what her own medical record says. And then, there is the suicide hotline call. Lindsay called a crisis line that had been given to her by a provider. She said she wanted to die. She said she did not care if she died. The clinician on the other end said she did not meet criteria for inpatient treatment because she did not have a specific plan. So they recommended a day program. And then, according to testimony, nobody ever sent the patient resources. She called for help. She said the words, and the system told her to wait.
She met with a clinician virtually and was told that she did not meet the criteria for inpatient treatment due to not having any suicidal ideation plan.
So if she said, in addition to the fact that she's been in counseling and therapy and seeing psychiatrists and on medications for the past 3 months or whatever the period ultimately would be, and that she wanted to kill herself, didn't want to be here, couldn't care if she died, they told her because she didn't have a plan that they couldn't help her?
Correct.
Did they, to your knowledge, make any recommendations? Or did they recommended that she attend a day program?
Yes.
All right. And that person from Aspire then said he would send her patient resources, right?
Correct.
But nothing ever happened. He never sent her any. You did, but he never sent her any patient resources, right? If you know.
Not to my knowledge.
Okay.
Now, I know what some of you are thinking right now, because I have seen the comments. People are saying this is just the defense spinning medical negligence to excuse the killing of 3 children. And I understand that. There are a lot of people online who have already made up their minds. Lock her up. She's a murderer. I saw those comments this week. But here is what I would ask you to consider. If we accept that Lindsay Clancy was a loving mother who could not even sleep train her baby, without feeling like she wanted to die. If we accept that she sought help over and over and over again from doctors who never once saw her in person, if we accept that she was prescribed 13 medications in 4 months, and that one of them carried a black box warning for homicidal ideation, then what exactly did the mental health system think was going to happen? There is a witness the defense wants to call. Her name is Emily Thorndike, and she is a licensed clinical social worker in Massachusetts. She worked for 8 years at McLean Hospital, the same facility where Lindsay Clancy was admitted on New Year's Day, 2023.
Your Honor, basically, as the motion speaks for itself, there is a woman, her name is Emily Thorndike, who's a LACSW here in Massachusetts. She owns and is an independent operator of her own clinical social work establishment called Wise Mind Therapy.
That's this woman who made a TikTok a few weeks back. She used to work at McLean, the medical facility Lindsay Clancy stayed at in late 2022 and early 2023.
When a patient is admitted to the unit, they are specifically assigned 2 clinicians. One is a psychiatrist, and the second is the social worker. You are literally told as a patient, this is your treatment team. This is your doctor. This is your social worker. With that being said, legally, every patient needs to be seen at least once a day by a doctor. So on the weekends and on the holidays, when the physicians in charge, the regular physicians who are working there, are off because they work weekday hours, on the weekends and on holidays, the patients still need to be seen by a doctor. How that works is that there is one doctor who comes on the weekend and holidays, and he or she sees every single patient on the unit, okay? And if you think about it, there's a reason that the doctors who are there during the week are only assigned 4 to 5 patients, because you cannot spend a long amount of time as a doctor with 23 different patients.
Last week, the defense made it known they want to call Emily as a witness. Their motion reads in part, Ms. Thorndike literally worked the unit that Lindsay Clancy was presented to on New Year's 2022-2023. Ms. Thorndike would testify based solely upon her firsthand observations and 8 years of experience while employed at McLean Hospital's short-term unit between 2014 and 2021.
She is not an expert on Lindsay. She is an expert on the place. And she says the prosecution is misrepresenting what actually happens at McLean on a holiday weekend. She says patients do not see their assigned psychiatrist every day. She says on weekends and holidays, one doctor covers the entire unit. She says the idea that Lindsay was turning away treatment or refusing care does not match what she knows about how that unit actually operated.
Her involvement in this case came about after one of the prosecutors, I don't recall which, made it out on direct examination that McLean is some kind of a 5-star institution where the doctors, the psychiatrists, the psychotherapists, the counselors were all banging into each other in the hallway trying to interview Ms. Clancy, who was just blithely refusing care and treatment, which is not the case.
The Commonwealth had some reservations about this potential witness.
Aside from that, we have a number of other issues with this witness. One is this isn't somebody that's proposed to be an expert, so they're not relieved, they wouldn't be relieved of a sequestration order. But this woman's TikTok, admittedly, she's been following the trial. She goes on for several minutes in a very long TikTok video where she identifies what she thinks are lies based on her observations of Patrick Clancy's testimony. We have no idea what her thoughts are or what her comments are on the rest of the trial that we assume she's watched based on her comments in this particular video. That she outlines in this video her experiences at McLean and her observations and how they are different from what was portrayed in that particular witness's testimony.
The judge has not ruled yet on whether she will be allowed to testify. But think about what that cross-examination would look like. A social worker who actually worked the same unit, telling the jury that the Commonwealth's description of McLean is not true.